Welcome to the Deep Dive, where we take a stack of sources and extract the fascinating core, giving you the knowledge you need without the overwhelm.
Exactly. You want to get informed quickly, thoroughly, and that's what we aim for.
Today, we're delving into a set of rules that governed a very personal, very significant area of life in England and Wales.
That's right, the Matrimonial Causes Rules of 1973. Sounds a bit dry, maybe.
Maybe a little, but the impact wasn't dry at all, I imagine.
Mm-hmm.
So let's unpack this. These rules were made November 29th, 1973,
Uh-huh. Laid before Parliament December 18th that year.
and came into operation January 11th, 1974.
So we're looking at the specific legal procedures for divorce, nullity, that sort of thing.
Exactly. In the Supreme Court of Judicature, that's England and also the county courts back then.
Right. So our mission then for this deep dive.
It's really to pull out the most crucial procedural bits. How did you actually do it? How did the legal system handle divorce and other matrimonial issues at that specific time? Okay, so where did that legal journey even start for someone wanting to, say, end a marriage back then? Let's talk commencement.
Well, the rules gave a couple of initial paths. One was quite specific, an application under Section 3 of the Act, probably the Matrimonial Causes Act 1973 itself.
Okay, Section 3, what was that for?
It was for asking permission, leave, basically, to file for divorce before 3 years of marriage had passed.
Ah, the 3-year rule. That feels like a pretty significant waiting period. Right. So what did you need to show to get that early permission? It wasn't automatic, I assume?
Oh, definitely not. You had to show you genuinely tried to reconcile. That was key.
Reconciliation first. Makes sense. What else?
You also had to provide particulars, specific details of the hardship you were suffering or what the rules called the depravity of the other spouse.
Depravity. Strong word. Reflects the times, maybe.
Very much so, I think. The emphasis was really on trying to keep the marriage together. You also had to say if you'd asked for leave before and mention any other relevant circumstances.
So quite a hurdle just to start early. What if you got permission? Or if the 3 years were already up? How did it officially kick off then?
Right. Then the cause, as they called it, began with filing a petition. Rule 9 is the one that laid out exactly what needed to be in that petition.
Rule 9. Okay, lay it on us. What were the must-haves?
Well, the petitioner, the person filing, had to state if they knew about any other related legal proceedings happening outside England and Wales.
Okay, international context.
And also any other related proceedings within England and Wales, crucially, details about any children. That was vital.
Naturally.
Yeah.
The basics of the marriage itself.
Yes, the date and place of the marriage. And of course, the grounds for the petition, the actual legal reason you were seeking the divorce or nullity or whatever it was.
Got it. Covering all the bases. Were there any sort of niche petition types with special rules?
There was one, yeah. Jactitation of marriage.
Jactitation. What's that?
It's basically when someone falsely boasts or claims they're married to someone else when they're not.
Ah, right. So if someone was doing that, what did the petition need?
It had to state the residence and domicile of both people, the dates and places where these alleged boasts happened, and clearly state that the claims were false.
Okay, a specific tool for a specific problem. And signing these petitions, who did that?
Simple enough. It had to be signed either by the solicitor, if one was acting, or by the petitioner themselves if they were doing it on their own. Rule 13 also mentioned the necessary parties, usually the other spouse.
Right. Petition drafted, signed, filed. What happens next? How does the other person find out?
That's the service part. Rule 14, very important. The petition had to be served on the respondent, the other party.
And how is that done typically? Post.
In person.
Generally, yeah. Personally or by post.
Yeah.
Standard ways.
Were there, special circumstances?
Yes, there were specific provisions if the respondent was under disability, maybe lacked legal capacity, and the petitioner could also ask the court for a different method of service if needed.
Okay. And once served, the respondent couldn't just ignore it, right?
Yeah.
No, absolutely not. They were required to acknowledge they had received it. There was a specific form, Form 6.
Form 6, Acknowledgement of Service.
Exactly. It confirmed they were aware. And if they didn't send it back, well, the rules had steps for the petitioner to prove service another way.
So proof was key. Okay, they've got the petition, they've acknowledged it. What could they do then? Could they fight it?
They could. Rule 15 gave them the option to file a notice of intention to defend.
Intention to defend. How long did they have?
8 days. From when they were served, it was their formal signal to the court saying, yes, I'm contesting this.
8 days isn't long.
Yeah.
What if they missed that deadline or just didn't file it?
Well, if no notice came in within those 8 days, the petitioner could potentially just move ahead with the case as undefended.
Ah, so that could speed things up considerably.
It could. It clearly marked whether it was going to be a contested case or not.
Okay, but what if the respondent didn't want to, like, fully defend the whole thing, but maybe didn't agree with the reasons given? Say, the grounds.
Interesting point. Rule 16 actually covered that. A respondent could consent in writing to the decree being granted.
Even if they disagreed with the allegations, like unreasonable behavior or desertion.
Exactly. They could basically say, okay, grant the divorce, even if they didn't accept the specific story told in the petition. Those consent had to be written down formally.
A pragmatic route, perhaps?
Okay.
But let's say they do intend to defend properly. What happens then? Pleadings? Is that the term?
That's the one. If the respondent was defending or disputing the facts, they had to file an answer to the petition, Rule 18.
An answer. And when was that due?
Within 21 days after the time for filing, the notice of intention to defend had run out.
Right, so a bit more time for that. And what goes in the answer? Their side of the story.
Pretty much. They'd state clearly if they were defending, disputing the facts, and then lay out their own version of events, their counter-arguments.
And could the first person, the petitioner, respond to that?
Yes, the rules allowed for a reply from the petitioner to the answer, and potentially even further pleadings if things needed more clarifying between them. It was a way to narrow down the issues.
Like a structured written argument before any court appearance. Could they change these documents later if needed? Add something.
They could, yes. Rule 26 allowed for amending pleadings, but you generally needed the court's permission leave to do it.
Right. Can't just change things on a whim. Keeps it fair. Okay, pleadings exchanged. What's next in getting ready for a potential trial?
This brings us to preparation for trial. A key part, especially in defended cases, was Rule 28, discovery of documents.
Discovery. That sounds important. What is it?
It's where each side has to tell the other about, and usually show them, any relevant documents they have relating to the disputed issues. It's about transparency, avoiding surprises.
Making sure everyone sees the relevant paperwork. Makes sense.
Hmm.
Any other tools used in preparation?
Yes, a couple more. Interrogatories were possible.
Interrogatories.
Formal written questions one side sends to the other, which have to be answered in writing, under oath. Also, specifically in nullity cases challenging the validity of the marriage itself, medical examinations could be ordered if capacity was an issue.
Ah, okay, for specific types of cases, and setting the trial date and location.
Yeah, the court could give directions for trial, which would sort out the timeline and decide which court would actually hear the case.
So getting all the evidence and logistics lined up. When it came to the actual evidence presented in court, what was the main rule?
Rule 37 stated the general principle. Evidence was normally given orally, witnesses in the box testifying under oath.
The traditional way. Any exceptions? Could you use written statements?
Sometimes. Rule 38 allowed affidavits. Those are sworn written statements in county court proceedings. And Rule 40 dealt with how you prove a marriage that happened outside England and Wales. Specific proof needed there.
Okay, different rules for different evidence types. And getting witnesses to court.
Rule 41 covered issuing witness summonses, the formal order, telling someone they have to come and testify.
Right. So mainly spoken evidence, but with ways to handle written statements and foreign marriages. Now, the trial itself, how are they generally run?
Well, Rule 43 touched on the mode and place. Usually trials were in open court, public, unless there was a good reason for a private hearing.
And could they split up complex cases? Decide one issue first?
Yes, Rule 44 allowed for the trial of a specific issue separately if the court thought it was sensible. And Rule 47 was interesting. It mentioned further directions on trial dates, but also putting certain cases onto a special procedure list.
Special procedure list. What was that about?
It seems like it was for cases that met certain criteria, allowing for a more streamlined, perhaps faster resolution. An early form of case management, maybe?
Interesting. Okay, trial happens, then come the official decisions. Decrees and orders.
Exactly. Rule 55 and onwards dealt with these. You had the decree, nisi the first stage decree.
Which doesn't actually end the marriage immediately?
Correct. Then later the decree absolute, which is the final divorce decree. Rule 56 explained how someone could apply to cancel or rescind a decree nisi if circumstances changed or something was wrong.
And making sure people got copies of these important orders.
Yes. Rule 58 covered serving copies of decrees and orders, and then Rule 61 brought in the Queen's Proctor.
The Queen's Proctor. Sounds quite formal. Who were they?
A legal official, yeah. They had the power to investigate a case, even after the decree nisi, if there were suspicions of, say, collusion between the parties, or if facts had been hidden from the court.
Really? So a kind of safeguard for the integrity of the process.
Kind of, yeah. A historical role tied to ensuring divorces weren't obtained improperly.
Fascinating. Okay, so the main divorce or nullity is sorted, but often that's not the end of it, is it? Finances, property.
Absolutely crucial, and that's where ancillary relief came in. Rule 68 set the stage for applications about financial provision maintenance, maybe, and property adjustment orders, things like that.
So dealing with the money side of things, how are those applications made?
Typically, according to Rule 69, by filing a notice using a specific form, either Form 11 or Form 13, depending on what relief you were asking for, it would set out your claim.
Right, so these 1973 rules really tried to cover the whole journey, didn't they? From thinking about starting right through to sorting out the house and money afterwards.
They really did. If we sum it up, you see this structure: the initial hurdle of maybe needing leave, then the petition itself serving it. The respondent's options, defend or consent the pleadings to define the fight, preparing for trial with discovery, the trial evidence, the actual trial, the decrees.
And then the ancillary relief for finances. It's a comprehensive framework, even if it feels quite dated now.
It really is. You see the level of detail, all aimed at managing these incredibly personal, often difficult situations within a legal structure.
It makes you think about the balance they were trying to strike.
Exactly. Fairness, efficiency for the courts, but also, respecting the privacy of the people involved. It's quite a balancing act.
Definitely gives you a real snapshot of how divorce law worked procedurally back then.
Which leads to maybe a final thought for you, the listener. How do these procedures from 73, born from that specific time, stack up against how things work today?
Ah, good question.
Maybe digging into how family law procedures have evolved since then. Well, that could really show how society's views on marriage, divorce, and fairness have shifted over the decades. Something to ponder.